Hello everybody, welcome back to our SSCMA classes. So we are going to resume our law classes for CA final and CMA final students. So this is going to be our second lecture of board meeting at SPAR. Okay, so today's first topic is going to be quorum of board meeting. Now what is this quorum of board meeting? Under section 174 which which is of quorum for board meeting. This is number of director which should be presented in board meeting. Okay, so which says that the 1/3 of total strength should be quorum. Okay, 1/3 of total strength. Now comes what is this meaning of total strength? Okay, let's go for the first criteria of this topic. Okay, the first criteria was 1/3 of total strength. Okay, and second was 2 director, whichever is higher among them, Okay, so let's read it again. 1/3 of total strength have to be rounded off as 1. Okay, if the digit comes in decimal form, then we have to round off as 1. Is this part clear? Yes, this part is clear. Now the things come, what is the meaning of total strength? Okay, let's read out. Total strength shall not include, this means that the total strength shall not include the directors whose places are vacant. Okay, which means they are absent. Okay, they are not present in the board meeting. Okay, let's go for it again. This was the case of normal board meeting. The quorum of board meeting should be either 1/3 of total strength. Total strength is not going to include the directors whose places are vacant. Okay, and second, 2 directors, minimum 2 directors, whichever are higher among them. Okay, we are going to take quorum of board meeting. Okay, but what about company license under section 8? Okay, if section 8 company have not made default in filing of financial statement, remember section, okay, and annual return. Okay, section 137 and 92, remember. Okay, in case of company license under 8 have not default in filing financial statement and annual return, in that case quorum of board meeting of section 8 company is going to be 8 members or 25% of total strength. Again, total strength means same thing, directors whose place are vacant. Okay, is it clear? Now among these we are going to take the lower or higher. In section 8 company, the quorum is going to be either 8 members or 25% of total strength, but we are going to take lower among them. Okay, we are going to take lower among them, but remember the quorum should not be minimum less than 2 members in case of section 8 company. Is it clear? So quorum as per section 174(1) subsection 1 specify the quorum of board meeting should be at least 1/3 of total strength. Okay, or 2. Okay, whichever is higher. Okay, but in case of license company under section 8, we are going to take 8 members or 25% of total strength. Okay, whichever is lower. Okay, let's go for the next part. Okay, here comes the example. Okay, so there are total number of director which are 10. Okay, total number of director present in board meeting are 7. Number of director left. So please make sure, is this the same meaning of the number of director who left, and where is that here? Or the directors whose places are vacant. These two terms are same. You have to identify this first. So let's go for the example first, then I'll tell you this. Okay, so total number of director are 10, number of director present are 7, number of director left were 4. Okay, so as per quorum under section 174 subsection 1, quorum should be 1/3 of total strength or 2 director, whichever is higher. Okay, total strength is 10. So do you think we are going to take this, or we are not going to include 4? Okay, 10, we are going to deduct 4 from 10. Do you get my point? I mean, whether we are going to take 10 directors or we are going to take 6 directors. Okay, the number of director left is not equal to director who have vacated. Is it clear? Again we are going for the law words. Total strength shall not include director whose places are vacant. Okay, these are the director who came to board meeting and in between they left the board meeting. So for calculating 1/3 of total strength, we are going to include them, okay, which means they are 10 in total number. Okay, so 1/3 of 10 is going to be 3.33, and as the law says, we are going to take the round off as 1. So this is 4 in number. Okay, since 7 directors are present at the time of commencement of board meeting, let's go for the question again, which says that total number of directors were present at board meeting was 7. Okay, so is this board meeting going to be validated or not? Here comes the question. Okay, since we got round off the total number of strength of 4 or 2, whichever is higher among them, so the quorum of board meeting should be at least 4. Okay, so we have 7 directors presented at the time of commencement of board meeting, which means this board meeting shall be validly held. Okay, so this part is right. Let's go for the next example where total number of directors are 9. Okay, number of director vacant. Here is the thing which law is saying. Let's go back again and read that word sentence which is saying total strength shall not include directors whose places are vacant. Okay, now let's jump into question. Okay, which says that total number of director 9 in number. Okay, number of director vacant are 2. Did you get what I mean to say? So we are going to take total strength as 9 minus 2, which would be 7. 7 is going to be our total strength in this question. Okay, so 1/3 of total strength or to director, whichever is higher among them. Okay, total strength is not equal to director whose places are vacant. Okay, this part was clear to us. Total strength is 7. Yes, 1/3 of total strength is going to be 2.33. So we are going to take as round off, which is 3, and whichever is higher among them, which is 3. So 3 would be quorum of board meeting. At least 3 members should be present there. Okay, otherwise board meeting is not going to be validated. Okay, let's go for the other thing. Same point of this. Okay, this section 174 subsection 3. Quorum as per section 174 subsection 3. Okay, earlier we was 174 subsection 1, right? Let's read out again 174 subsection 1, and now we are going for 174 subsection 3. Okay, now where at any time, earlier I was talking about every director. I haven't mentioned about any particular directors. Okay, but in this section 174 subsection 3, I am going to specify some director, only one director I mean. Okay, I am going to specify one director, and please pay attention here. Okay, where at any time the number of interested director are interested director. There is something new to us. Now this, what is this interesting director under section 184? We'll read this, okay, but not in this lecture. Okay, so where at any time the number of interested director present in the board meeting exceed or is equal to 2/3 of total strength. 2/3 of total strength. In that case, number of remaining director or 2 director, whichever is higher, that is going to be quorum of that board meeting. Now let me read again. I know right now we don't know what is the meaning of interested director under section 184. Okay, so we have to know this, but not in this lecture. Okay, but let's read out, like there is some director whose name is interested director. In that case, what is going to be the quorum? If again I'm going to read it, please again. Okay, where at any time the number of interested director present in board meeting exceed or is equal to 2/3 of total strength. Okay, when the board meeting, the member who are present in board meeting, okay, which exceed 2/3 of interested director, in that case what is going to be the quorum of that meeting? Either the number of remaining director, which means disinterested director. The law has specified that we are not going to take the interested director. Okay, if the number of director present in the quorum, present in the board meeting are more than 2/3 of interested director, in that case what is going to be the quorum? Okay, either 2 directors, we know this, or the number of remaining directors, whichever is higher among them. Let's go for example first. Okay, here's the example where total number of directors are 15 in number. Okay, interested director are 13 in number. Interested director under section 184 is 13 in number. So remaining are 2. Disinterested director is going to be 2, right? Is this part clear? Yes. So we have to identify what is going to be the quorum here. Okay, under section 174 subsection 3, where at any time the number of interested directors, okay, exceed or is equal to 2/3 of total strength. Again, where at any time the number of interested director exceeds or is equal to 2/3 of total strength. In that case, the number of disinterested directors present at meeting being not less than shall be the quorum. Okay, so here is the solution. Number of director present is 15. Okay, total interested director are 13. What I told you, interested director, we are going to calculate 2/3 of interested director, which is 10. And here in this question, since number of interested director present board meeting is 13, okay, which is more than 2/3 of total strength. So what is going to be happen? The remaining 2 directors who are not interested directors shall constitute the quorum. That was the second option, right? Either minimum 2 directors should be there, or the first was a number of remaining directors. So here in this case, with 13, there are a number of 13 interested director, right? And total directors are 15 in number. So the remaining disinterested director would be 2, right? And the second option we say that there should be at least minimum 2 directors, right? Whichever is higher, 2 are in both cases. So we are going to go for 2. Okay, the quorum should constitute 2 director. Okay. Okay, let's go for section 175, passing of resolution by circulation. Board is required to grant its approval, okay, either by board meeting or passing a resolution by circulation. Okay, the provision regarding passing of resolution by circulation may explained as follows. Condition for passing of resolution by circulation, either the circulation of draft resolution to all the directors. The circulation should be circulated to all of the directors, right, to their respective address, right, or by hand delivery, post, courier, electronic means, either through electronic email or fax under rules 5. They are saying that if the company want to pass the resolution, grant, in case of company is required to grant its approval, they are going to take it either in board meeting or by the circulation of, by the resolution, by passing a resolution of circulation. Okay, but there are some condition for passing resolution by circulation. The company have to circulate the draft resolution to all of its director, to again whether it is interested director, additional director, nominee. So whatsoever the director is, the circulation of draft resolution is to be passed to every director, okay, to their respective address, either in hand delivery, post, courier, electronic mode, or email or fax, and under rule 5. Is it clear? Yes. Approval of resolution is to be done by majority of directors. Otherwise, the resolution will not be approved. Okay, until and unless majority of directors have given consent over the topic which is going to be discussed or which is discussed. Okay, so no demand for decision at board meeting. If the chairperson shall put the resolution to be decided at board meeting. What happens sometimes, the the number of favorable votes and against are equal in number. In that case, the chairman is going to make the conclusion. Okay, the chairperson shall put the resolution to be decided at board meeting in that case. Okay, is it clear? Okay, let's go for the next topic under section 176, validity of act of directors. Now what is this? Section 176 seeks to give protection to the company and third party with certain acts are done by director in good faith and without notice that are done wrongly or illegally. Okay, what happens sometimes, the company give protection. The company give protection to whom? to either third party, okay, and certain acts are done by director even in good faith, okay, and without noticing that that these are done wrongly or illegally. So these are the provision under these things where some things are going to be validated, okay, and some are not validated. So let's go for it. Act as director is validated. Now what is this? If the appointment was invalid, what is the meaning of invalid? The director's appointment was disqualified, remember, or he have made any default, or due to some reason the termination of director happens. In that case, his appointment will be not valid, okay. Second, act of managing director not validated. When the managing director ceases to hold his office, right, so whatever the act was, whatever the duties performed by him will not be valid, the decision making by him will not be valid, okay. Act of director not valid in cases of, again, where the director's appointment is either in illegal form, okay, terminated, invalid, act of directors are ultra vires, okay. So in these case, again, the directors act are going to be not valid, okay. Act of chairman, again, not valid. If chairman's appointment was invalid, in that case, again, his acts will automatically not valid. So this was section 176, validation of act of director. Now comes section 177, rule 6. 177 is of audit committee. Let's go for the diagram first. Section 177 is a constitution of audit committee. Now which company have to constitute audit committee, right? Every listed public company, again, right? Every public company, but for every public, I'm not saying that every public company, but there are some specified category. In these public company, they are again paid up capital of 100 crore or more, right? Turnover of paid up of 10 crore or more, turnover of 100 crore or more, aggregate outstanding loan, debenture deposit of rupees 50 crore, which is going to exceed. Remember, the same criteria was somewhere, okay. So comment below which criteria, the same criteria was somewhere in which section, okay. So now we have to, composition of audit committee is done if the company is coming under these criteria, either it is every listed public company or the public company, right? The same criteria. I hope so you remember these criteria, so I'm not focusing on this, okay. So the composition of audit committee shall consist minimum 3 directors, okay. Majority of composition of audit committee should be independent, okay. So again, however, the following classes of unlisted public company shall not be required to constitute the audit committee, which are joint venture, wholly owned subsidiary, or a dormant company, okay. Now what are the composition of audit company? As I told you that there should be at least how many minimum number of director? 3 in number. There were at least 3 minimum directors in the composition of audit committee, okay. The majority of member of audit committee shall be independent director. Yes, the majority of member of audit committee shall be have the ability to read and understand the financial statement. Is it clear? Yes. Every audit committee or company existing immediately before the commencement of actual within 1 year of such commitment constitution as per the provisions. They are saying that within 1 year of commencement of company should constitute this audit committee if they are falling under the criteria, okay. Let's go for the functions of audit committee. The recommendation of appointment of terms of appointment of auditor of company is one of the function performed by audit committee. Review, monitors the auditor, independence and performance of audit progress is to be given by audit committee. Again, examination of financial statement and audit report are done by audit committee. Approval, modification of transaction of company which is related to related party, Okay, scrutiny of intercorporate loan and valuation of undertaking of asset of company. Okay, I'm just reading out because we know these functions which are performed by audit committee. Okay, evaluation of internal financial control, evaluation of management system, monitoring the use of fund through public force. Okay, now what are the power of audit committee? The audit committee have power to call or to comment on audit or internal control system, right? To tribute the financial statement before submission to board, power to discuss any issue with respect of financial statement, yes. Have authority to investigate related to board, which is matter related to board. Okay, the company requires establish wiggle mechanism. Now this is something which we have to discuss. Okay, the audit committee shall oversee such wiggle mechanism. Okay, what are the disclosure which is made by audit committee? The board shall disclose the composition, okay, where the board does not accept any recommendation of audit committee. Okay, then in that case it should disclose the board report along with the reason. Sometimes what happens, the audit, if the board of directors, right, they are not accepting the recommendation made by audit committee, right, in that case the board they have to give the report or board report, right, and along with their reason should be specified that why they have not accepted the recommendation of audit committee. Okay, punishment for the contravention for company punishable which is not less than 1 lakh, same thing was written somewhere, right, up to 5 lakh, 1 lakh to 5 lakh, minimum 1 lakh, maybe extend up to 5 lakh. Okay, every officer who is in default shall be punishable imprisonment for term, may be extend to 1 year or with fine which shall not be less than 25,000 but may extend to 1 lakh. Okay, which is not going to be less than 25 but which could be extend up to 1 lakh, and imprisonment of at least 1 year. Okay, so that's it guys. This was the topic of section 177 audit committee rule 6. Okay, these were the same criteria, that's why I haven't emphasized on these criteria because I already discussed these prescribed criteria in some other section. Okay, so that's why I haven't given that much importance here. Okay, we are going for the next topic.